Thank you for your patience. Thank you for joining us. We should have a pretty interesting conversation this morning about the criminal justice reform and taking the next indicated steps. I'm going to say as little as possible because our true experts are sitting here at the table with me. So thank you, and I thank the criminal justice section for putting this presentation on the Fall Institute's calendar this year. And in particular, our speakers. I'm not going to spend a whole lot of time introducing them, except to say a couple things. One, you'll find their full resume on the website, along with the materials. There's a whole list of materials there of citations that you might want to pursue or peruse or add to in terms of criminal justice reform citations and resources. But I can say that Ms. McCurdy here, who works with the ACLU, she'll weave in a little bit of what she does along with part of her presentation, but she has extensive experience in criminal justice reform, worked on actually passing legislation that she'll talk about, worked on the Hill, is now working, as they say, with the ACLU. Liliana Coronado is also no stranger to federal criminal justice. She was a federal public defender, my colleague in the office in LA for several years, was a visiting attorney advisor with the on the House for the Subcommittee on Crime and Other Issues, then with now rest in peace Congressman Conyers, and after that she's now gone on as the vice president of the Brimley Group, which is a lobbyist group that has, amongst other interests, criminal justice issues that she'll talk about during her presentation. And of course, last but not least, the introduction in this group here is Jonathan Wroblewski, who is part of the Department of Justice over at the criminal section, criminal division of the Department of Justice, heading up the Office of Policy and Legislation. Was also an ex-official member of the U.S. Sentencing Commission for several years. Also is working with us on the Diversion Standards Task Force, so I know alternatives to incarceration and other cutting-edge issues are on his agenda and his personal interests. So again, you can look at their full resumes on the website under the Fall Institute. And I just want to say a very brief opening comment. So we're talking about reform, and you're going to hear about transformation, right? And reform in its generic sense is just to make change in order to improve something, right? So we've heard criminal justice reform being bandied around for a long time, but we're talking about change for improvement, right? Transformation, similar. Is it the same thing? Not necessarily. It's to make a thorough or dramatic change in the form, appearance, or character of something. And you'll hear, and Jonathan, I think, can address this, is we're hearing now about prosecutorial transformation, right? Changing the character of how that office or what that prosecution should look like. And I think one example we heard a few minutes ago from Rachel Rollins. Thank you, Rollins from the district attorney in Massachusetts. And we've heard others where there's a changing now of who is being elected prosecutor. And in terms of criminal justice reform, I mean, the issues that we can slice up are from beginning to end, right? From all the way from prosecution, policing on the street, all the way to post-conviction relief. And so, I think all of us have, a good idea of all the potential subjects in criminal justice reform. As I say, what comes to mind initially, or in broad strokes, is policing or deflection or referrals for services in lieu of arrest. Bail is a big discussion item. Alternatives to incarceration and diversion. What do we do with individuals that may have mental health or substance use disorders instead of just putting them in jail or in prison? Of course, what are crimes and offenses? Looking at the statutes, there's been some discussion of that in terms of the number of offenses that are on the books and the types. The distinction between felonies and misdemeanors, and maybe reclassification of certain crimes that's been done, for example, in California recently. And of course, in federal system, the use of mandatory minimums, right? There's a lot of discussion on either trying to eliminate those or trying to reduce those or apply them more selectively. With respect to prosecution, as I mentioned a minute ago, there's a shifting policy in some jurisdictions, looking for the election of more quote-unquote progressive prosecutors, looking at issues of restorative justice and those types of issues. With respect to trial and procedural due rights, of course, we're talking about, recently a trial. Is there a trial tax for people to go to trial? The whole use of plea bargaining. There's been a lot of discussion and things written about, the coercive nature of plea bargaining, where most cases now are resolved through pleas and what's lorded over a defendant's head. The guidelines, whether U.S. sentencing guidelines or state guidelines. Of course, there's a lot that's been going on in juvenile justice, racial and implicit bias, funding for public defenders. We've heard a lot about that on the state side. Use in the federal system, we still have use of either dismissed or acquitted conduct that can be factored into sentencing. Women, of course, in the criminal justice section is a whole other issue that we heard about quite extensively and informatively this morning. And of course, and then there's sentencing and correction issues, I think, where most of the discussion has been in recent years, right? We've heard mass incarceration for now several years, and why is that, and how does that come about, and what can we do about it? Now we've had, I think Jonathan will address the First Step Act in some part, and I know that there'll be a workshop this afternoon on the First Step Act, and what does that mean and how that came about. In particular, in the use of assessment tools and custody credits, conditions and programming for inmates to get out, female inmates, and use of alternatives. And of course, there's a lot on the post-conviction release side with respect to restoration of civil rights, ban-the-box type initiatives with respect to employment and housing and other public benefits for those who have been incarcerated or formerly incarcerated, and of course all the appellate rights and waivers that come about. So just coincidentally, as an example of how criminal justice reform, we can't either open up a newspaper or look at our journals or look at documents that are coming out on criminal justice reform. There's an article in the most recent issue of the Criminal Justice magazine, using the power of prosecutors to drive reform. This is by Eric Gonzalez, who just got elected in Brooklyn or Queens? Brooklyn, I think. I'm from California. We don't know about boroughs and stuff like that. I don't know how you guys got that, but no. I think is it Brooklyn? Brooklyn, yes. Okay, I got it right the first time. So there's a lot of discussion, obviously, about criminal justice reform. And I think the majority we'll talk about is what's happened. We're going to start off in a second with Jonathan because he'll give us a good history of where we've been and where we're at now. And then we'll go on to what's been done recently. What are the success stories and what's the groundwork that's being laid now for future changes or reform issues? And Liliana will round us up with telling us in terms of what are the interests of her clients, or what's out there in a nonprofit and private world about what are the drivers, or what are the interests for those individuals that come to a group like the Brimley Group or to Liliana to try to effectuate criminal justice reform. And the federal system, and I think in the state system, a little bit. Okay, so that's enough out of me. I'm going to ask Jonathan to take us away and to walk us through. Oops. Thank you. Okay. Jonathan Brzezinski.
Thank you.
Thank you.
Thank you, Raul. Thank you all for being here. We have a small group, so I'm going to talk. I put up a few slides. We'll go through them. If you have any questions, any input, if you think I'm full of shit, just please interrupt. Don't save space. Yes. Don't be shy at all. Thank you, Raul, for inviting me to be part of this. Thank you to the criminal justice section for putting this on. It's wonderful. It really is wonderful to be here. I should say right from the outset, nothing I'm saying is on behalf of the United States Department of Justice, okay? And especially given that there's a camera rolling, okay? So if you got that camera, okay, nothing I'm saying. It's just me, but anyway, I'm really thrilled to be part of this panel, and Raul sort of sets out quite a daunting task. There's so many subjects that we could talk about, and well, obviously we can't get through all of them. But what I'm going to try to do is give a little bit of a historical perspective on this. I think it's really important. We're in the middle in the federal system of implementing the First Step Act. It's going to take a while for it to get implemented. I think it's going to take a while to really realize the full import of this act. A lot of it doesn't actually take effect until early next year. So there's a lot of work going on that implementation, and that all is great. But I think at the same time, we're a year away from another election. We're a year away from a new Congress. And I think there's a whole lot more to do. And I think it's important after passing a law like the First Step Act to take a historical perspective and take stock of where we are and where we might go. So that's what I'm going to do. And like I said, I've put together a few slides and we'll go through them. So for me, when I think of the last 100 years or so, I think we really did in the 1970s and 80s go through a period of historical transformational change in criminal justice. It may be hard to see that right at this moment, but I think if you look back over history, you can see that. And those transformational changes included, come on in, we'd love to have you. Those changes included policing changes. We had new ideas about policing. Words like broken windows came into our vocabulary, and we had changes in constitutional criminal procedure. The Terry stop, that was created in the 1970s and 80s. We had changes in surveillance, changes in sentencing, changes in incarceration. It really was a transformational moment in criminal justice. And we're reacting still to that, and I think we have to keep our eye on that. So I'm going to just talk about it. I'm going to put up a graph, and I'm going to use this incarceration because it's something we're familiar with, and it's also something that's easy to graph. So this is a graph of the number of people in state and federal prison for roughly the last 100 years. And this is the first part from 1925 to 1972. And one way to look at that little part of the graph is that it was a fairly stable rate of incarceration. Another way to look at it is the number of prisoners doubled. So we went from 90,000 prisoners in 1925 to 190,000 in 1972. But the reason I think it's really a story of stability during that time is because, of course, the population in the United States also doubled during that time. So in 1925, we had roughly 100 million people in the United States, and there was a rate of incarceration of about 100 people per 100,000. In 1972, we had about 200 million people in the United States. We had a rate of incarceration also about 100 per 100,000. And with the exception of course, World War II, when we sent all of the young men, those who would be committing crimes and those who would be arresting others for committing crimes, they were all sent either to Europe or the Pacific. So our numbers dropped dramatically. But other than that little period, fairly stable, 100 per 100,000. And so what in the world happened in the 1970s and 80s that caused what I would argue was transformational change? And the reason I think it's important to go through that is because, again, we can start thinking as we look towards reform going forward, what might we be looking towards, and we might learn something from what was happening then. And so there were a number of things. I think the story can be simplified, and I think many authors try to simplify it down. So if you read The New Jim Crow, for example, it was all about drugs and race. If you read Jim Foreman's book, professor at Yale, it's a little more about crime. I think my view of the history is it's about a number of things, and I'll just sort of tick through them relatively quickly. I think it is a story about drugs, and I think we have to be very, very cognizant of the of drug use and drug abuse in the United States and the history of that. if we're going to come up with something sensible. We're at an inflection point when it comes to drugs. I'll talk about that in a minute. But there was a tremendous amount of use and abuse of all kinds of illegal drugs in the 1960s and 70s. As I say, I'll mention a little more about that in a minute. Crime was a big part of the story. Violent crime rose dramatically. You'll see a few graphs about that. It later dropped dramatically. It's something we definitely need to keep our eyes on. It was part of the reason why we had transformational change then. Race was a part of the story then. It was, we were going through a civil rights movement at the time. There were all kinds of racial animosities in our country, many of which we still have today. Race was a huge part of the story. Rachel Rollins talked a little bit about that. Many others have written about that. But there were other things that sometimes don't get looked at, and I think it's important to touch on those. It's also a story about mental health. So just as an example, there was a reporter, a news reporter back in the 1970s. Some of you may have heard of him. His name was Geraldo Rivera. Anyway, he did a story. He cut his teeth in local news. You heard of him?
He went to law school with Jerry Rivers.
Yes, I know. He was Jerry Rivers. Anyway, he did a story in New York about an institution for the mentally ill called Willowbrook, and that's actually how he first became famous. But there were stories like that and changes in mental health and a de-institutionalization around mental health in the 1960s and 70s and 80s that also contributed to transformational change. There was also tremendous unrest in the country in the 1960s and 70s. We may not remember it, but it wasn't just that we had unrest around a civil rights movement. We had unrest around the Vietnam War. We had tremendous divisions in the country. We had protests going on in the streets, violent protests, things that may almost seem unimaginable now. The President of the United States was murdered. His brother was murdered. Dr. King was murdered. Lots of people were murdered. Even the head of the American Nazi Party was murdered in my hometown of Arlington, Virginia in the 1960s and 70s. So there was tremendous amount of unrest. And that was a very significant, I think, contributing factor to the transformational change. And finally, for us lawyers, we really can't escape it, and it's something we don't usually talk about, but it was a period of law reform. The Model Penal Code was created in the 1960s and 70s. All kinds of other law reforms were happening. There was a code reform project going on in the federal system that led to something called the Sentencing Reform Act. Reform was happening, law reform was happening across the country. For my friends in California, there was a young governor at the time who created something called determinate sentencing laws. Do you remember that young governor? His name was Jerry Brown. Yes, these names never go away. They're all around us. Jerry Rivers, Jerry Brown, they never go away. Anyway, law reform was part of all of these issues came together in almost a perfect storm to create what I would call historic policy change. And what does historic policy change look like? Well, in this one aspect, and again, I don't want to just focus on the number of people in prison, but this is what it looks like. Okay, you take the graph that we had, and this is the graph that we had beginning in 1972. And it's an amazing change, which I know we've talked about this for many, many years before, but it's still, every time I think about it, I just can't get over it. From 1926 to 1972, a period of 46 years, our prison system grew at about 2,000 prisoners per year, which is about the size of one good-size state prison. And that was the steady state for the early part of the century. And then from 1973 to 2009, our prison system grew by 36,000 prisoners a year, every single year for that entire period of 36 years, which is an astounding amount of investment. It's the equivalent of building 18 prisons a year, year after year after year for 30-some years. That's, to me, transformational, historic change. And it was going on not just in sentencing and corrections. As I say, it was going on in policing. There were all kinds of new ways of policing. There were growth in the number of police officers. A tremendous change, again, in surveillance. Constitutional practice was changing. As I mentioned before, the Terry stop was created, and all kinds of other things were going on at the time. And I think it's, again, important to look at it this way, because as we think about where we go next, which is the subject of this panel, I think we should be thinking about all of the different aspects that actually led to the transformational change. It's not to say, I think it's very easy for us and an instinctive response to just push back on everything that went before, because we think that where we ended up was not particularly good. And I would recommend, and I push for, a thoughtful approach to each part of each of the factors that led to the change, some of which should be rejected completely, and some of which requires, I believe, a more nuanced response. So, for example, on drugs. The history of drugs in America is a history of cycles. We are, as Americans, we think we found something new, and we're going to push back against the old, and we're going to create some new utopia. That's what it means to be an American. And we have done it with drugs over and over again, back and forth since the beginning of the country. We have periods of permissiveness, followed by periods of temperance. During the permissiveness periods, every new substance is a medicine that's going to cure all ills. And we go after it, and we embrace it completely. And then we realize, usually at the end of these periods of permissiveness, which usually last 40, 50 years, that, oh my God, these aren't the greatest things in the world, and you actually can abuse some of them, and they can be quite dangerous. And then, of course, because we're Americans, we go way the other way. In fact, believe it or not, we amended our Constitution in the early part of the 20th century to prohibit the use of alcohol. It's astounding that we did that, but that's what we do. And so we've gone through these cycles. In the colonial era, there was an incredible amount of alcohol that was consumed, far more than any period of time during our lifetimes. There was an initial period. The first temperance movement in the United States happened in the early 1800s. And during that period of temperance, more than half the states also had prohibition. Then we had a period of permissiveness again in the mid to late 1800s. That was the period of time where we thought that if we take some cocaine and we put it in our soda, and I don't know, let's call that Coca-Cola, and that somehow that's going to make us feel better, it's going to improve our lives. And so we did. And we actually sold over the counter a drug, an opioid that was called heroin. That's a brand name. Heroin's a brand name of the Bayer Company. And we sold it over the counter. We thought it was the greatest thing in the world until the end of that temperance and that period of permissiveness. We think, oh my God, these are horrible because they can be abused. And then we go through the period of prohibition. Then after prohibition, after World War II, another period of permissiveness. Anybody ever see the show Mad Men? Okay, everybody's drinking and smoking. That's what permissiveness looks like. That was my youth. That was my parents who were drinking. And then, of course, at the end of that period of 40-year period of permissiveness, cocaine is back. Oh, and by the way, even the president's chief of staff is using cocaine. This is President Carter's chief of staff is using cocaine at a place called Studio 54. And that's what permissiveness looks like at the end. And it goes too far, and people are dying of heroin use in the streets of Baltimore and elsewhere. And then we have the war on drugs. Okay, that's our third temperance movement. And where are we now? We're coming out of it, all of it. And you can see it all. It's happening just exactly as you would think if you were a historian. Now, all of a sudden, marijuana is medicine. And, marijuana, let's go to the next stage. Oh, psychedelics, that's medicine. Okay, and I don't know where we're going, but if I were guessing 30 or 40 years from now, if we don't come up with sensible drug policy, I'm not suggesting continuing the war on drugs. I'm not suggesting mandatory minimums. I'm just saying, let's think thoughtfully about it and come up with sensible policies. And let's do it for all of the different aspects that led to the criminal justice transformation of the 70s and 80s. So keep our eyes on crime. Yes, it's a good idea, I think, to try to reverse mass incarceration. But if we don't keep our eyes on crime, we're not going to fulfill the promise that we have. And the story of crime is an interesting story. I'll try to get through this relatively quickly. This is what crime looked like from 1960 to roughly 1991. And it's part of the reason we had the transformational change that we had. Of course, after 1991, as you all know, crime has been decreasing and decreasing dramatically. That doesn't mean we've solved the crime problem. It means that crime is significantly lower, and there's room right now for lots of other reforms. But as we move forward, it's important as we think about things like bail reform and sentencing reform and all kinds of other reforms that we keep an eye as leaders in the criminal justice community on crime. So we have sensible drug policy, we have sensible crime policy. We need to deal with racial disparities. We have not solved those problems. That has to be part of the solution. Mental health has to be part of the solution. Unrest, this is the divisions that I'm a little bit afraid of. I love Rachel Rollins. She came to my class. I teach at Harvard Law School. She came to my class. I think it's fantastic. What I hate, what I see in law schools all around is that you have prosecutors over here and you have defender people over here. There's no mixing. There's incredible divisions. There's incredible suspicions, each side towards the other side. And I think it's a real shame. And I don't think we're going to reach the best possible reform, new transformational reform, unless we somehow get rid of that and find a way, pardon me, that we can all get along. And I hate to say it, the person right now, it pains me to say it, but the person right now who's actually doing the best job of all of this right now is Donald Trump, okay? He speaks to the law enforcement people and says they're the greatest. And he speaks to people who are coming out of prison and say that they deserve a second chance. We have to be able to speak to both sides. We cannot vilify law enforcement. We cannot vilify people who end up in the criminal justice system. We have to be respectful, and we have to find a way not to have the divisions. The divisions will not lead to good things. Okay, and then finally, law reform. This is especially where the lawyers need to be part of it. Our criminal code in the federal system was never reformed. The reason we have over-criminalization is because legislators, their job, anybody know the job of a legislator? To pass laws, make laws, and guess what they do? They make laws, okay? And they don't get rid of laws. They don't really, pare laws back. They just add new ones upon new ones upon new ones. And every so often there needs to be a review, and we need to take some of them away. We need to rationalize the system. In the federal system, we don't have any, unlike many of the states that are model penal code systems that have standardized mens rea elements, standardized punishment levels. We don't have anything like that. We have a huge mess, and we need new reform, both criminal code reform. We need sentencing guideline reform. Our sentencing guidelines at the federal system were built for a completely different time. They're a complete mess. They need to be changed. There's a whole lot of work to do on all of these aspects. This is the 30,000-foot picture, just to give you a sense of where we are back from that original graph. That's the change that we've experienced so far, okay? It's important, it's significant. I think it's kind of historic, but I wouldn't call it transformational quite yet, okay? I think that there's a way that we can get back to that original line, that original blue line of 100 per 100,000 people, and we're not there. And I think the only way to get there is to keep our eye on all of the pieces, all of the factors that originally led to transformational change.
So, I have a question. What does account for this last dip there?
Well, there have been changes. First of all, most of the numbers actually comes from two places. California, where there was a court-ordered realignment, which meant that there had to be about 35,000 prisoners released from the State Department of Corrections. And I hate to tell you, I hate to take credit for something, but yes, this is the federal system.
Yeah, that's right.
And the federal system accounts for 40,000 more. This is where we were. The federal system was 220,000 as late as 2011. and now it's about 175,000. So almost more than 40,000 fewer people. So most of the reduction in the state and federal prison population is California and the federal system. Other states have had some decreases, but that's the biggest chunk of the decrease. Yes.
New York and New Jersey have done well as well.
Yes.
I want to suggest another factor. I was looking at a graph regarding the income disparity in our country, and I was shocked that it looked very similar to the graph that you showed regarding the increase in prison populations. Around 1980, the gap between the rich and the poor dramatically increased and has gone up to today. And I wonder if that is also a possible additional.
Well, you'll have to talk to my son, the economist, because now you're out of my expertise. So where that played, what role the economics played in rising crime and rising, I don't know. But I think I'm not sure it really was the trigger for the changes from the 70s and 80s. Those changes, again, policing, surveillance, sentencing, incarceration, I think those were more tied to the crime rate, drugs, race, than income inequality. But I'm no expert in the economics.
Can I ask one more question?
Of course.
And is it, Jonathan, is it mainly with regard to drug offenses that we've seen this reduction?
You're talking about an incarceration?
Yeah.
At the federal level, no, it's large. I mean, it's significant. The reduction in the drug offender population is significant. But no, there have been changes in others. The mix in the federal system is a strange thing, and it's been changing over the last 10 years or so. We've had a grand reduction in prosecution generally in the federal system. We used to prosecute 85,000 people a year, and now we're closer to 70,000. And the mix has also changed, so there's many more immigration cases prosecuted these days. So it's not just that the drug sentencing policies have changed. They have changed, and that's been a contributing factor, but it's more complicated than that.
All right, thank you, Jonathan. Let's hear from Jonathan. Yeah, I'll ask now Jocelyn McCurdy to come up and share a few words with us.
Sure.
Forward.
Thank you so much, Raul, and thank you, Jonathan and Liliana. Really glad to be on the panel today with you two. Been working with both Jonathan and Liliana for years now, bugging Jonathan a lot when he was on the Sentencing Commission. So I'll ask you, Jonathan, to actually, if there are things that I maybe get the dates a little off on in terms of kind of my own history that I want to talk about today, feel free to correct me. Because believe it or not, even though I lived through this, sometimes you forget the date, like things get fuzzy, right?
Things get blocked out.
Exactly, right? Yeah, or that, right, exactly. So again, I'm Jocelyn McCurdy. I am currently one of the deputy political directors at the National Political Advocacy Department at the ACLU. I have been working on criminal justice for 15, 16 years now. Well, even though 20 years, even before that, I worked with the Children's Defense Fund on juvenile justice. And so a few months ago, the Cardozo Law Review approached me about writing an article on the First Step Act. And I kind of took a while to accept because I was trying to figure out, oh my God, do I want to be spending a lot of time writing a law review article? Time that I do not have. But then I thought, I think it's important to talk about, and then when I started thinking about what will I write about in terms of the First Step Act, I started thinking about how I wanted to write about actually the fact that, and this fits into Jonathan's discussion too, around transformational change, reform, how the fact that the First Step Act actually was not the first step. And actually, it is the next step after 15 years of successful incremental reforms on the federal level. And I thought, I want to memorialize that history because A, it's important to not try to rewrite history, and B, it's important because it tells a story about how so many different policy changes and so many different levers on the federal level actually resulted in what Jonathan talks about, the 40,000 people who are 40,000 less people who are in federal prison today. And they were policy changes that happened well before the First Step Act. There were also things that like seminal moments that like triggered like people's consciousness to realize that we had a mass incarceration problem in this country and we had to do something about it. And elected officials needed to address it. Bureaucrats needed to address it. The public needed to address it. And so I'm going to go through a little bit of that kind of history over the past 15 years so that it's not lost. And that, for example, the next time around when or in the future, as we're talking about reform, we understand that it's not just going to Congress and passing the First Step Act, because that's a long road, right? The First Step Act, or even the Fair Sentencing Act, which I'm going to talk about a little bit, to get to that end road is a long road, and there are a lot of other things that can happen in between passing the bill in Congress and achieving reform. So as Jonathan talked a little bit about, in 2013, 219,000 people in the federal system. As of today or yesterday, 177,000 people. Between 2005 and 2019, a combination of legal, legislative, executive, and U.S. Sentencing Commission law and policy changes have, in my opinion, have resulted in that decline in the federal prison population. I think one of the things that I really want to focus on today, one of the key factors is the Sentencing Commission. And I think the Sentencing Commission kind of does their work in D.C., doesn't get a lot of fanfare. Jonathan has worked very hard with the Sentencing Commission, on the Sentencing Commission, but their decisions have been critical in this 15-year timeline of reform, because even more so than the First Step Act, and the provisions of the First Step Act that have resulted in people coming home from prison, the work that the Sentencing Commission has done between 2007 and 2014 has been even more significant in terms of in terms of putting cutting that prison population that was at an all-time high of 219,000 in 2013. Former Attorney General Holder was musing about how the Bureau of Prisons was almost taking up about, I think, 30% of his budget, and that this growth in the federal prison population was just unsustainable. So let me move on. So again, I'm trying to tell a story about accurate story of reflecting the real history around the political environment that was built over the past few years that even allowed us to talk about a First Step Act in a Congress that was Republican with a Republican president, and to get that across the finish line. So even before Jared Kushner, who I give a lot of credit for getting across the finish line, or Van Jones became interested in these issues and this reform on the federal level, you had many advocates, criminal justice, civil rights, faith-based advocates who were coming together, bugging Jonathan at the Sentencing Commission to make changes to sentencing guidelines, for example. And one of the first examples of that was the 2007 crack cocaine sentencing guideline adjustment. And that was after United States versus Booker. Again, the Supreme Court decision where the sentencing guidelines were no longer mandatory. And the Sentencing Commission really began to take responsibility on some level for the racial disparities that they continue to see in the system based on the sentencing guidelines that they had adopted. And those were, and Jonathan, please jump in whenever you think necessary. So the problem with the sentencing guidelines were that the sentencing guidelines were above the, not well, they were set above the mandatory minimums. And that often contributed to even more racial disparities in the system, because people because judges felt like they had to sentence people above the mandatory minimums. And so what the Sentencing Commission did was they bumped down the sentencing guidelines by 2 levels and then ultimately applied that amendment retroactively. The application of a sentencing guideline reduction, first to have the courage to change the sentencing guidelines on your own, not based on, for example, a bill that passed Congress. Because at this point, there were discussions about addressing the crack cocaine disparity in Congress, but not enough a political will was behind it yet to do it. So the Sentencing Commission, again, and with, I think, a lot of courage, stepped out there and said, based on our authority, we're going to lower the guidelines by 2 levels, which will get the mandatory minimums within the guidelines and not force judges to sentence people over the mandatory minimums. And then to have the courage to apply that change retroactively. Again, we're talking about 2007. We're not talking about 2019, right? We're talking about 2007 to then apply that retroactively and allow people to be resentenced based on that was a huge, huge movement in reform here in Washington. Because you had someone that was saying, we see that there is a problem. We are judges, we see these cases every day. A lot of judges, not all judges on the Sentencing Commission, obviously, but many are judges, and they see these cases every day, and we see that there's a problem. We're going to make a move to change the guidelines to try to address that. And then I think another turning point that maybe people don't think about, but I again, as an observer of this process over the past 15 years, when the Pew Charitable Trust came out with their report in 2008, crystallizing the fact that in this country, we have 1 in 100 people on any given day in jails and prisons. That I also think was a really critical inflection point in this advocacy around reform, because, and you saw the numbers based on Jonathan's chart, you saw how the numbers had gone up. It gave people a concrete vision of what our justice system look like. And it gave people, because again, we're talking about prisons, so people are behind closed doors. You don't know what's going on in prison. People are always like, put them in prison and throw away and throw them away and throw away the key. Lock them up and throw away the key. Well, what the Pew report gave us was, wow, 1 in 100 people. Again, now 2.3 million, again, once you add jails into Jonathan's number, 2.3 million people in this country, 1 in 100, are in prison and jail on any given day. And I think for the public, for elected officials, it created a picture of this country that didn't look good. Like, we were number 1, but we were not number 1 in a good way, right? We're incarcerating more people on any given day than like countries like South Africa, Iran, and Germany. And so I really think that kind of vision for our system was a very critical turning point in these conversations about reform. I mean, and realistically also, is 2008, there was a recession. States could no longer afford to maintain prisons and jails, a criminal justice system in a way that they were doing in the past. And they had to make conscious decisions about, when they looked at their budget and they saw, well, we're spending most of our money on jails and prisons or the criminal justice system. What do we do? And this was in red states as well as blue states, but red states more importantly. What do we do about this budget line that's costing us so much? And do these people really belong in prison or jail? So I think the Pew report gave people the mindset that they needed to change the way they thought about incarceration. I think the realities of the 2008 recession did. And then President Obama was elected, and President Obama kind of had considered criminal justice as a priority issue for him, even though he didn't focus on it as much in the first term. But he did, as you see from the slide, he did one of the most significant, again, on the trajectory of reforms. One of the most significant things he did was support the Fair Sentencing Act, which changed the crack cocaine law. And as well, the Department of Justice also kind of changed its position. For many years, it had supported the crack disparity, but then back in 2008, when the discussion started happening about changing it, they were definitely more supportive of it. And President Obama ultimately ended up being, hold on, I think I've gone too far, an important voice to reform in the efforts to reform in his time in office. And you'll see more of that coming up. So in March of 2010, the FSA was passed by the Senate. In July, passed by the House. It represented a decade-long effort to reduce racial disparities in the system. And here's another, I think, important inflection point on reform over the past few years, was when Attorney General came to the American Bar Association and gave his speech about the critical reforms and the change in the way the Department of Justice was going to prosecute and address drug crimes. And basically saying that at that time, there were people were not automatically going to be charged with mandatory minimums. We were going to be more thoughtful about the way we did it, and only in egregious cases, and issue guidance to that effect, and which was commonly known as a Smart on Crime initiative. As a result, and Jonathan pointed to this also, a lot less people were being prosecuted for drug crimes. It sounds like that downward trajectory continues, and particularly drug crimes carrying mandatory minimum sentences. And in 2015, the number of mandatory minimum drug offenses that were being prosecuted had dropped to 45.8%. And then another important inflection in the trajectory of reform was the Clemency Initiative. So for many years, advocates during the first term of President Obama were asking him to use his commutation and pardon power more often to address some of the clear injustices that existed in the federal criminal justice system. And then soon after his election in 2012, I think it felt like it was safe to try to come up with a process to do that. But I think he was really trying to work with Congress to really get legislation done. But when it became apparent that was going to probably be difficult, even over the next 4 years, he decided to work with the Department of Justice to come up with the Clemency Initiative. And that was basically a process where cases would be reviewed based on 6 different criteria to determine whether or not people's sentences could be commuted. Then one of the ways as advocates we saw that after all the years of trying to encourage him to take on the more cases to commute those sentences, we saw that he was listening to us was back in 2013 in December, when after only, I think, commuting in his first term or first few years, maybe like 2 sentences, he commuted the eight sentences of several people who had crack cocaine offenses, 6 of whom had life sentences, and they affectionately call themselves the Obama 8. And several of those cases were very egregious cases that people had been tracking for years. Clarence Aaron was one of those cases. He had, I think, a triple life sentence, and he had very tangential involvement in a drug while he was in college. And so that was also an inflection point for us as advocates that he hears our cries. And then I'll really just end on the fact that the Clemency Initiative itself, right, got off the ground in 2014. Ultimately, President Obama commuted 1,715 sentences. Over 500 of those sentences were individuals who had life without parole sentences, would have never seen the outside of a federal prison. Very, very significant. And even on his last day, he granted 330 commutations at the time, which was the largest set of commutations at the time. I think Liliana will talk about something more recently that just happened. And over that time, he also pardoned 212 people. So I just really want us to keep in mind that, again, the first step was not the first step and was not the most significant reform that has happened on the federal level over the past 15 years. Really, the Sentencing Commission is responsible for some of the most significant reforms that have happened over the past 15 years, because if you look back at the numbers from the Sentencing Commission, there is, I think from the original crack cocaine amendment, there is as many as like 1,600 people who have been resentenced, and similar numbers very much for 2011 when the Fair Sentencing Act was passed and the Sentencing Commission had to amend the guidelines to be consistent with the Fair Sentencing Act and then apply those guidelines retroactively. And then here's, again, even the more courageous point of inflection for the Sentencing Commission is in 2014 when they took the same concept of the 2007 amendment and applied it in what is commonly known as drugs -2. And that was a lowering of the guideline, 2 levels lowering of the guideline for all drug sentences, all drug crimes, and applying that retroactively as well. And those have resulted in many, many people being resentenced and many of those people being home now. So I'll stop there. Thank you.
Thank you. Thank you, Justin.
You gonna help me get mine up?
Yes, of course.
Quick comment.
Yes.
It's interesting to note that President Obama was the first American president to visit the federal.
That's true. I was going to put that in there. I just started running out of space. Yeah, no, absolutely. I'm glad you said that. Yeah.
Forward.
Yeah.
Okay, great.
All right, Liliana.
Thank you, Raul, and thank you for inviting me to speak today. I was thinking about my journey to this place here. It's called the Beltway, and it's interesting. I was, as Raul said, a federal public defender for over a decade, and I worked with Raul, and we made a lot of mischief together. It was fun. I did a detail where I was privileged to work alongside of Jessalyn McCurdy, who really doesn't give herself enough credit, but she is, I would argue, the leading advocate on this issue in Washington. So I was working with her on as counsel to the House Judiciary Committee, and then I went back to the defender and back into the courtroom. And now I'm a consultant, what they call a consultant here, basically a lobbyist working on these issues. And I have the privilege of talking about what's happening in this very interesting congressional session on criminal justice reform. And so you all know that a lot of interesting things are happening up on the Hill, but I'm talking just with respect to criminal justice issues. And I'll say what Jessalyn also said, if the people at this table can feel free to chime in, because if I really could predict sort of what the next steps were or what was happening in this Congress, I would be making a lot of more money than I'm currently making. But I know that we're all sort of doing our best to kind of talk about and think about what makes sense next after the non-First Step Act. I think Jessalyn is in the better position to talk about sort of how First Step happened. I did work on some very discrete pieces of that for certain clients, and so I saw the really broad left-right coalition that came together to get that done, and the way people had to really push for sentencing reform, the way people had to negotiate exclusions, and so it really is years and years, as both of these individuals have talked about, to really get a piece of legislation like the First Step Act done. And so now, of course, the conversation turned immediately to what the next steps are. What can we do next? Can we do anything next in federal criminal justice reform? Should we be looking more at the states? I mean, immediately. And organizations like the ACLU and the Leadership Conference have put together their priorities for this Congress and are talking all about that. And we should probably add that to your list of resources. But in terms of my time that I spend on the Hill and working on behalf of clients to see what can be done, you sort of pick up what the conversations are like. And I have seen that there's really 3 kind of buckets, if you will, even though it goes 1, 1, 1. I'm not sure why it's doing that, but it should be 1, 2, 3. PowerPoint is not my strong suit. Number one, there is the first piece. I hope this is the right version. The first bucket is really oversight of the implementation of the First Step Act. And so there is a lot in terms of what Congress is doing, and specifically the Judiciary Committee on the House side, to hold DOJ's feet to the fire, if you will, about implementation, because there's all this really years of work to get it done. And there's a big celebration or moderate celebration, and then there is implementation. And what is it going to take to make sure that it's actually implemented faithfully and that people are being respectful and mindful of the spirit of the law? So that's one bucket that I think is taking a lot of time, as it should, on Capitol Hill. The second one is I think people have been introducing and have introduced these larger messaging bills, if you will, these bills of like talk to sort of emphasize that we got some stuff done in First Step Act. It wasn't the first step, it was a baby step. It was an incremental step. And so we have a lot more to be done. So there's some bills around that really are looking at all the other pieces of the criminal justice system, as Raul already outlined. There are a lot of areas ripe for reform. And so there's some comprehensive bills about trying to tackle some of those that really are just sort of trying to keep the conversation going, if you will, trying to keep the momentum going, even in this difficult time and right before an election year, so that for the next Congress, perhaps, and the new administration or the next administration, there can be a continued conversation on this issue and continued reform efforts. And so there are some bills that are like a public defender's dream, but may not be happening very soon. And then the last bucket is, I think the stuff that falls into this category has the most chances of actually getting done, because they are targeting very specific and discrete flaws, what I would call flaws in the criminal justice system. And they're sort of smaller bills that hopefully we can attach to something else or can be done on a bipartisan basis. And I'll talk a little bit about some of those. I'm going to run through some of this quickly because I'm mindful of the time, and I know people want to have a discussion. I would hope we can have a discussion about what I'm not going to talk about, which is some of the GA stuff that somebody brought up earlier, and other lots of areas for conversation. But so Congress, what they've done on First Step so far in terms of oversight, they have been doing a lot of letters of inquiry and asking a lot of questions about this independent review committee that is a part of the First Step Act, that is supposed to help the administration develop, validate the risk and needs assessment tool. And they have spent a lot of time asking questions about that committee and trying to conduct oversight of that committee so that we can ensure, because that's really the key, at least to the portion of First Step that involves earned time credit. The key is this risk assessment and needs assessment that will allow people incarcerated to earn pre-release credits and also other kind of benefits. And so they've done a lot of oversight over that. They've done some oversight over this good time credit fix that was part of First Step, and trying to find out, there's an issue when it was going into effect. So they've asked DOJ a lot about that and trying to make sure that gets done. And it actually did get done according to the statutory deadline. And then there's a concern about the BOP's capacity to actually provide what First Step Act requires them to do, which is to provide programming that would allow people to reduce their risk of recidivism such that they're able to take the benefits that the bill outlines. And so the questions have been really around, do they have that capacity? Do they have the funding to do that? They held a hearing with the Bureau of Prisons director last month and the Department of Justice to talk about these issues. So they sent a lot of correspondence, and they had an oversight hearing. They talked about First Step quite a bit, although it wasn't limited to First Step, but BOP in general. And then there was a non-government panel that talked about some of the concerns with the risk assessment tool that they have released, and are having that ongoing conversation with how that tool needs to be tweaked, if you will, to make it better. There was an impacted person on the panel, some advocates, a defender, a researcher, and so people are engaging in this conversation about how we can faithfully implement First Step. There it is, the development of the risk and needs assessment tool. DOJ released a report on the tool, not the tool itself, but a report so that researchers and advocates and defenders could take a look at it, and prosecutors, everybody could take a look at it and give comments and provide feedback. There are significant concerns that the tool creates bias and racial and ethnic disparities and perhaps is not as gender responsive as it could be. And so there is a process for giving that feedback to the DOJ, and hopefully we'll see some changes to that. I know that Congress has asked for more information on that, and that the DOJ is going to be seeking to validate that risk assessment tool, so having a third party come in and take a look at it and ensure that it is, that you can, I mean, there's a whole conversation about risk assessments in general, but to the extent that we have one in First Step, the question really is how can we make it the least biased as possible? They may have a briefing on the First Step Act to talk about the issues that came up, and the needs assessment called for by First Step is supposed to be conducted by January of 2020. So that really is when I think we'll see what the needs of the population are, and if the BOP has the programming or what they need to beef up in order to be able to give incarcerated people adequate programming to be able to get early release or get other kinds of benefits. So that's been taking, I think, a lot of time of the committees and the Judiciary Committee specifically. Then there are all these legislative proposals, and I'm sure there are some that I am not talking about because there's a lot going on that people are introducing as marker bills, as messaging bills. But very shortly in this new Congress, I would say Senator Booker and Representative Watson-Coleman introduced the Next Step Act. And so this is incredibly comprehensive. It includes a lot of other criminal justice bills that people had introduced separately. It would do all of the things that people think still need to be done, like reducing these mandatory minimums, reducing finally to one-to-one the crack and powder cocaine disparity. I was just talking to someone who was like, why can't we get that done? It's like, oh, that's a long conversation, but it still needs to be done. It really does. And the conversations have shifted around that, but because the Fair Sentencing Act, but bans racial and religious profiling. There's ban the box legislation in it. All kinds of things that need to be reformed in the criminal justice system. It's all in this bill. There are no Republican co-sponsors of this bill, as you can imagine. So this is really a messaging bill. Addresses collateral.
Can you talk about what a messaging bill is?
Yeah.
Go ahead. A messaging bill is a bill a lot of times that we don't necessarily expect to get passed in this Congress, but it's introduced and we talk about it so that we can educate people about the bill, so that maybe it's more long-term,
right?
Type of, in terms of the legislative process is more long-term, that it would get across the finish line, but it's out there and you do events and you just talk to people about it so you can educate people about the need for it. So.
Thank you. Exactly. This Congress is the Next Step Act. I think a couple Congresses ago, it was Bobby Scott's Safe Justice, which was also very similar and also had things like open file discovery and things that just, we're good for conversation and messaging, but not necessarily realistic. There's a lot of conversation about marijuana reform and the racial and ethnic disparities in the marijuana statutory laws and the ways they're enforced. And so there are several bills on marijuana, but this is the chairman of the House Judiciary's bill, along with Senator Harris, that would decriminalize marijuana essentially, also be retroactive and allow for expungement. They had the House Judiciary Committee, who is democratically controlled, had a hearing about marijuana. It's a big priority, I think, in the progressive community, and so the conversations are happening. But this bill has only one Republican co-sponsor, so we have a heavy lift there. It also does this issue with respect to collateral consequences for immigrants, and so it's a good bill all around if you are an advocate on this issue, but it is, again, more of a marker / messaging bill. The Second Look Act, and actually DC has a Second Look Act, which I don't know a lot about, or effort to pass a Second Look Act, which would essentially allow judges to take a second look at people's sentences and allow someone to petition themselves for that process. This particular bill is a Booker bill, Senator Booker and Representative Bass, who is the chairwoman of the Crime Subcommittee of the House Judiciary Committee, and it creates a rebuttable presumption of release. So it would allow people this process, and the government would have to show why they should still be incarcerated. The Fair Chance Act, moving on now to some of the proposals that may actually get done in this session. The Fair Chance Act is a ban-the-box type of legislation that would prohibit the federal government from asking about prior criminal history until after they made a job offer, a conditional job offer. It passed the House already as an amendment to the NDAA, and it didn't. In the House version contains it. The Senate version does not contain it, but they are reconciling these two bills, and the hope is that it will be included in the final NDAA spending package. I know that, I think it was Congressman Budd, Republican from North Carolina, made a speech on the floor recently after Congressman Cummings passed away, talking about this bill and talking about the importance and the urgency to pass it generally, but also as an honor to Congressman Cummings, who worked very hard on getting this in there. And so this is something that we're hopeful that we may see done this Congress. And again, it's a small change. It addresses a very discrete piece of the system, but it's really beneficial to people who are trying to reform their lives and reenter into the community after having a conviction. And so, I mean, there's a whole conversation we can have about incremental change versus transformative change. I mean, listening to Jonathan, I was thinking like, it took a long time to get where we are. It's going to take an even longer time to get back. Mm-hmm. And so some conversations around whether, we need to push harder or should we settle for things like incremental change, they're all valid pieces and points of discussion. But the reality is that Congress, even though there is, there has been support and bipartisan support for some of these efforts, works in an incremental fashion. And they don't do what Jonathan said, which is going back and saying, maybe we should go back and look at the crack cocaine disparity until people like Jesslyn and the whole coalition get together and say, that was a huge mistake. For years and years and years, they said it before it happened. This is another bill, the REAL Act, is another bill that people are doing a lot of work on both sides of the aisle about. It has bipartisan support, and it would lift the Pell Grant ban on incarcerated people receiving Pell Grants. That was passed back in 1994 when we were in the middle of the tough on crime kind of period in this country's history. And so, again, a very discrete, modest, if you will, criminal justice reform policy that would be very meaningful to people in custody who are seeking to better themselves as part of their time in custody. And it was included as part of, because it's an education issue, it was included as part of the Education Reauthorization Act in the House and the Senate. There is some concern that neither of those bills right now are bipartisan, but the REAL Act itself is bipartisan. So it was included as a part of these larger education bills. And we are fearful but hopeful. We are fearful that it might actually, that it could get bogged down in some of the larger fights about education reform, like Title IX and campus safety and campus sexual assault, because it's literally like a very simple bill that just strikes that ban from 1994. But people on both sides of the aisle, it's sort of reminding me of some of the same groups that worked on First Step and some of these other things that are coming together to talk to Congress and say, we need to get this done. There's another discrete bill called the Prohibiting Punishment of Acquitted Conduct Act that Senator Durbin has introduced in the Senate, and does not have a House companion yet, but it would basically prohibit the use of acquitted conduct in cases. And again, really discreet, really simple, should be a easy lift, kind of low-hanging fruit, bipartisan, but meaningful, especially for those of us who are or were practitioners. We know with that how far that will go and how important that can be to individual cases. And again, it has some of the champions on it from First Step, for sentencing, Senator Grassley, who was the chairman at the time the First Step Act was passed, Senator Leahy, Senator Tillis, Senator Booker, and Senator Lee, who incidentally is the Republican lead on the REAL Act to lift the Pell Grant. I know discussions are underway for introducing a House companion to that bill, and I know that they're hoping to get Congressman Collins, the ranking member of the House Judiciary Committee, but it hasn't happened yet. But we'll keep our fingers crossed that that's something that's attainable, perhaps, this Congress. I'll say there's all the, this fact that there's a re-election, there's an election next year, a presidential election next year, the fact that we're really in the home stretch for this year will affect all of this and really kind of creates a sense of urgency around the reforms that people are really pushing. And everyone's sort of pulling out all the stops, if you will, on some of these smaller pieces that they think we might be able to get done. But it is a challenging environment to get anything done. Some people say that there is no legislation happening at all right now, or very little in Congress. And so we're in an uphill battle, but that's always the case with criminal justice reform. And as a public defender, I'm not unfamiliar with that type of fight. So there are other efforts, and I'll go through this real quick, in state court and other kinds of initiatives that people are engaging in to try to advance the reform conversation. I know that the House Judiciary Committee in Congress is about to have a hearing next week, which you can actually live stream if you want to, on bail reform. And this is an issue that has gotten a lot of attention in some states. This is an issue that people are talking about on the Hill and off the Hill. That needs to happen in terms of the over-reliance on cash bail and money bail. So they're having a hearing. There's no specific bill that I understand that they're going to put forth right now, but they're having a hearing to sort of examine the issue and look at other possible reforms, problems in the bail reform, in the bail system, and what might be done. And typically, from working on the Hill, and I'm sure Jonathan knows this too, that you try to have a hearing to sort of lay the foundation and set the mood or the tone for what you might introduce as a bill. But I haven't seen it or heard of anything necessarily that they might do this Congress on this issue, except try to spur this conversation. I know that there was a bill last Congress that Senator Harris introduced. She hasn't reintroduced it this year. I'm not sure why. But it would do, it would just allow for, it's a grant program, which is still important, but I haven't seen any other bills on that issue. States are making an effort in this regard. California had an interesting bill last session that basically reformed the system. It started off pretty strong in terms of the way that the progressive community felt about it, and then there were so many changes made to it that I think the California affiliate of the ACLU pulled out of it, did not endorse it, but it essentially was seeking to abolish money bail. And then a couple other interesting sort of research-based things that folks are doing at the Urban Institute to look at prisons and try to see what the next step in prisons reform may be at the state level. And they're bringing together researchers, impacted people, practitioners, to try to have that conversation. We talked last night, Jessalyn and I, about the clemency grant in Oklahoma and those kind of state efforts. And that was, I think, the largest grant of clemency or commutations in the history of the country. And it was precipitated, though, by several pieces of legislation that made changes to the law and enabled that to happen. And I know other states are looking at that as well. So I know that was a lot of information. I know I talked fast, but I know that we're out of time. So I'm going to sit down and see. Here's my last slide, Raul, that I wanted to see if you wanted to talk about, see if people had questions about. But we were talking about ways that people might get involved in this effort.
Right. So she has up there obviously getting involved in ABA sections and committees. I think this section and several of our committees are very active in that. Letters of support, the collection of data, and so I kind of feel like I'm preaching to the choir. I think, like I said, this section has been very active. I know James Feldman back there has testified before Congress, and many other opportunities, and Sandy, our previous section chair, but that was kind of one of the underlying things. Let's look for any and all opportunities for us to help effectuate this change, short-term and long-term. I know we're kind of out of time. I will have to take probably a couple of quick questions, but I just want to remind you that there is a list of sites that you can get on the website. I'm going to ask that we update it. And both Jessalyn's and Liliana's PowerPoint will eventually get up on the website too for that information. And last but not least, I'll make this a quick statement. James Feldman has a session this afternoon at 2:30. speaking specifically about the First Step Act and the pattern risk assessment tools. So things that you're talking about, James will get into detail. Yes, sir.
With regard to drug policy and possibly a new way forward, I was fortunate enough to go to Amsterdam in the Netherlands for a couple of weeks to study their handling of the situation. And I thought it was very illuminating. They separate soft and hard drugs. Soft drugs are basically legal and available in coffee shops throughout town. It generates income, it has jobs. It seems to keep the young people somewhat content. And the harder drugs are classified, they say, let's take morality out of the equation, and they classify addiction as a medical problem. And initially they gave out hard drugs, and people were laying around, needles everywhere, it was a disaster. But then they brought it into the medical system, and you go to a clinic and you get your heroin or whatever, and you leave. There were 272 opioid deaths last year compared to 75,000 in the United States. I was there several days before I even saw a police officer. I mean, crime is virtually non-existent. And to me, this suggests that this is a policy that we should seriously look into.
Yeah. Thank you. Yes, Sandy. Thank you.
You know, what's interesting is there are on the federal level, y'all talked about the bipartisan efforts, but even in other states, Jim and I are from Florida, and there are bipartisan efforts in Florida as well. You know, how far they're going to go, I don't know, but there are a number of, we had a criminal justice summit that the Florida Bar put on last year. Some bills have come out of that on a bipartisan basis. I mean, issues like solitary confinement for young people. Mm-hmm. You know, maybe this time we'll get a bill. So, you know, there is at least for some reason, and maybe it's dollars. I don't know, Jonathan, but there is a bipartisan concern in states like Florida or Oklahoma or other states that we need some reform.
And you had a First Step, a version of the First Step Act passed, right? Right. But as I understand it, but correct me if I'm wrong, but it didn't have sentencing or maybe there were a few in the end, a few sentencing reforms included in it.
I think there's some sentencing things in there, aren't there? In the Florida First Step
I didn't think so. What they did do was try to make it so that felons could vote, and then the Republican-controlled legislature kind of tried to undo that.
Yeah, but that was different.
That was Amendment 4, right? That was a ballot amendment, right? That was a ballot amendment.
But I'm talking about in the legislature. There's
right.
a number of bills out there, so we'll see. I mean, because of gerrymandering, even though we're a 50-50 state, the legislature is heavily Republican,
mm-hmm.
but there is some interest.
Okay.
Sometimes the states have led the way, really.
Yeah, well, they really have.
I mean, First Step was supposed to be modeled after some of the successes that the states had,
right? And
some of that being, again, driven by the rising corrections costs, perhaps, but still being done in states like Oklahoma and states like Texas, really doing reform before the feds did this particular piece.
Thank you. Any other questions? Please join me in thanking this august. Thank you.